Welcome to U.S. Immigration TV. Well, the Violence Against Women Act, or VAWA, allows spouses of U.S. citizens and lawful permanent residents, called LPRs, to file their own self-petition for a green card if they were subjected to battery or extreme cruelty during their marriage. Now, many people believe that VAWA applies only to women and that they have to have suffered physical abuse by their U.S. citizen or LPR spouse, which must be documented with police or arrest reports or hospital records demonstrating injury. Well, this is not true. So make sure to watch this video until the end, because if you are a victim of battery or extreme cruelty during your marriage, maybe you could be eligible to self-petition. Now, VAWA can also apply to husbands, and a person could be eligible for a green card if they can demonstrate that they had suffered extreme cruelty, even if they were never physically abused. Now, according to the USCIS, or U.S. Citizenship and Immigration Services, extreme cruelty is different from battery or physical abuse. It means, among other things, it is a non-physical act of violence or threat of violence demonstrating a pattern or intent on the part of the U.S. citizen or LPR to attain compliance from or control over the self-petitioner, meaning they're very domineering. And this extreme cruelty can come in many forms, including the following, and see if this applies to you: isolation, humiliation, degradation, use of guilt, minimizing or blaming, economic control, coercion, threatening to commit a violent act towards the self-petitioner or the self-petitioner's children, like I'm going to beat the hell out of you, acts intended to create fear, compliance, or submission by the self-petitioner, controlling what the self-petitioners do and who they see and who they talk to, like, I don't want you talking with your family anymore. Speak only English, not Tagalog. Denying access to food, family, or medical treatment. Threats of deportation. Acts that may not initially appear violent, but are part of an overall pattern of violence or control. Acts aimed at some other person or thing that may be considered abuse if the acts were deliberately used to perpetrate extreme cruelty against the self-petitioner or the self-petitioners. Now, my office has handled several VAWA cases where no physical abuse was involved. Instead, we were able to demonstrate extreme cruelty through the stress and the anxiety the client was suffering, such as where the American citizen refused to petition them ever, or they threatened to withdraw the petition, threatened to have them deported. They would not let them speak with or visit with their family members. They treated them really like a prisoner or a housekeeper. Or they were perhaps taking drugs, gambling all the time. The American was not working, but they expected the spouse to work hard and support them. They may have called the person all kinds of horrible names. Now, none of this involved physical abuse or harm, but we were able to convince the USCIS that this constituted not battery, which is hitting, but extreme cruelty. Now, if you are married to a U.S. citizen or an LPR and you are the victim of extreme cruelty, you may want to consult with an attorney who can evaluate your situation and determine whether it reaches to the level of extreme cruelty and whether you meet the other requirements. The attorney could also help you package your VAWA petition for green card. Now, if this applies to you, if you are the victim of extreme cruelty, even if the American or the green card holder hasn't beaten you up, you still may be eligible. That's why it's important to consult with an attorney. Well, I hope you have found this video helpful and useful to you. and therefore I would truly appreciate it if you would like, share, and subscribe to this channel. I'm Michael Gurfinkel. Thank you for watching U.S. Immigration TV.